The next case is Walker versus Underwood. This case is also an argument on the application. You each have 15 minutes. You can do your best to reserve some time. You've seen how that goes. Good luck.
Thank you, Your Honors. Good morning. Philip Maxwell on behalf of the estate of Otis Underwood. This case grew out of the restoration of a 19th century storefront in Lake Orion. My client was an attorney, and he drafted an agreement to lease. Not a lease agreement, but a preliminary agreement to lease. And the agreement is, I think attorneys don't always do their best work when they're representing themselves, but it's an agreement which should be read in light of the history of this building, which was a long battle with the township to restore it, litigation, distrust between my client and the township, so that when the agreement was written, it contains cautionary language about their obligations here that are unknown, dependent on governmental rulings which may go against us. There's no completion date in it. There's no requirement on the part of the potential tenants to contribute money, and they don't have any obligations under the agreement until they inspect the finished premises and accept them, which never happened. All of this after 4 years of litigation, summary judgment before Oakland County on behalf of Mr. Underwood, and then the decision in the Court of Appeals resolved down to paragraph 10 of the agreement, which is a remedy provision. And it basically says that the failure of either party to perform under the agreement will permit the obligee of the duty to declare a default and terminate the agreement. And then there's another clause that says, or other remedy that may be agreed to by the parties. The Court of Appeals majority never referenced the fact, which the dissent does, and which Judge McMillan did in Oakland, that there was never any allegation that there were other remedies agreed upon. They were never pled, and to my understanding, there was never any other remedies agreed upon. So really what you have here is a sole remedy clause. Judge McMillan said there's no ambiguity here. I don't think there's any ambiguity here. The majority opinion, I think, was overly technical.
Can you take us to paragraph 11, which references the lease agreement, which was never signed, and then when you get to the lease agreement, there's two paragraphs, paragraph 47 and paragraph 3. I mean, do we get into all of that?
No, I don't think that's even necessary to go to.
Why is that?
Because what happened was, after 9 months of back and forth with the township trying to get it ready to be inspected for occupancy, Ms. Cruzy, on behalf of her client, wrote a letter saying, we're walking, we're done. We don't want any further part of this agreement. In effect, utilized...
But paragraph 11 specifically states we're going to incorporate the lease even before it's signed, doesn't it?
But it also states that there's no obligation for them to sign the lease until they've inspected and improved the premises. So the lease was never signed. There was never a lease.
But that begs the question I asked. Doesn't paragraph 11 make reference to the fact that the lease doesn't have to be signed for the lease to be incorporated into the agreement?
Well, even if the lease were incorporated into the agreement, what effect would that have?
Well, it takes us to paragraph 47 and paragraph 43.
Of the lease?
Yes. paragraph 47 allows the parties to use any remedy available at law. But then that seems to be a little bit contradicted by paragraph 3, in my view.
Well, I would argue that since the lease was never agreed upon, the inspection never occurred, the only binding language regarding the remedy is what was executed by the parties in the preliminary agreement, which, if you felt the other party is not performing, your remedy is to declare a default and walk away. And although the majority refused to apply the construction expressio unius est, I don't think it's necessary to utilize that rule of construction, but I think it benefits my client's position because the failure to mention any other remedies available, because you mention one remedy, the express mention of one remedy excludes all others. It's interesting that the majority raised that and refused to apply it. But I think that as a rule of construction, to determine what the party's intent was, it is useful that we're talking about a category of things, remedies. One remedy is to, if you have a problem, you have the ability to declare a default and walk away. Or you could sit down and try to agree to other remedies. But if you don't mention...
Counsel, if you could help me understand, what's the jurisprudential significance of this case? Like what, if we were to craft an opinion, what would the impact be?
I think the real problem with the majority opinion is that they're violating the injunction against courts supplying words into contracts in order to provide a remedy that is not there. The Sandusky grain case is the one that comes to mind that was cited by Justice O'Brien in her dissent. I think also the rule of construction was misused, the expressio unius est was misused by the majority. It was applicable. It should have been used. Instead of, as the majority says, they want to insert a word or two.
Don't you have to insert some words into paragraph 10 to make sense of it?
I don't think so. I don't think you do.
So explain to me what or other remedy that may be agreed to by the parties. How does that fit into grammatically fit into the preceding?
I think I think you have to look at the failure of either party will permit the obligee to declare a default, or
You declare another remedy?
If I were drafting this now, I'd probably put in resort to another remedy.
You need some words to make sense of
But
this,
I
right?
don't think you need it to make sense, because I think you can use as the subject, the obligee, will permit the obligee to...
What's the verb? So
to declare a default, or other, there is a missing word, but it's not for the court to insert it. That's the problem.
Does that make it ambiguous?
It makes a contract for the parties.
Does
It
that
creates
make
a
it-
remedy that's not there. That's the problem with the
Does
majority.
that make it ambiguous?
I don't think so. I don't read it as being ambiguous, particularly since the point was that the parties never agreed to another remedy.
I don't understand what words are being added here. As I look at this, so this is kind of a rescission clause, and the court said that allows rescission. The only word that I see being proposed to be added is by you suggesting that there ought to be the word only or exclusively in there somewhere.
No, the word that I would have added if I was redrafting would simply say or resort to other remedies agreed by the parties.
Okay, well, those words aren't in there either.
Well, I understand, but I'm not saying, I do not agree that it's ambiguous. I think it's perfectly clear.
I didn't say it was ambiguous. I don't think it's ambiguous, but it's certainly at the very least unclear.
it isn't, as they say, artfully drafted. However, I do not think it's ambiguous, and I think that...
You said at the beginning it was ambiguous. You said that in your first couple sentences.
I don't think I admitted that it was ambiguous. I think I said that attorneys, when they're drafting agreements for themselves, often don't do their best work.
I thought you said that, but in any event, you later said that the problem was that the other side was trying to add words to it, and I'm trying to figure out what...
The majority opinion is trying to add words to it. In fact, they admit it. That's stated quite clearly in the majority's opinion when they talk about it requires the insertion of a word or words limiting the available remedies to those specified. I think the available remedy is exclusive, and it's very clear. If you have a beef, declare a default and leave.
And is that because there were no other remedies that were agreed to?
Why would the parties specify a remedy if they weren't going to limit
Well, it seems to me they specified two remedies. Either declare a default and walk away, or some other remedy.
Well,
Let me finish, please. It's not beyond the realm of possibility that when this is dragging on and on and on, the parties sit down and say, look, either you're going to fix this thing within a week, or else we want to pursue damages because we have been waiting a long time, we've lost business. So we're going to give you a week, but if you don't do it in a week, other damages. Now you've got your other agreement.
Well, there's no completion date in the agreement at all.
Well, I understand that.
And so in the only cause of action they would have had was that he didn't use reasonable efforts to obtain an occupancy
So what
permit.
meaning do you give to the or other remedy?
I would give meaning to it if they had pled something, but it was never pled. There was...
Doesn't the or other remedy have to be in the agreement itself or in a subsequent agreement that modifies this agreement?
I think the plaintiff would have had to have raised the issue in their complaint and relied on it. In fact, there was no other remedy agreed upon. So the language is inoperative, and it becomes an exclusive remedy provision, really.
The negative implication can and cannot be utilized if there are not at least two or more like remedies or like factors.
Well,
so you want to say it's inoperative, but you want the canon to still apply.
Well, I think the canon can be applied because you can look at both as being remedies. There's one remedy, which is walk away. The other remedy is what we agree upon.
Whatever you agree to.
So it's not like saying we're talking about dinnerware, pots, pans, and dishes. What about the silverware? That's excluded. But I think it can be utilized here because it is a discussion of remedies, but it's not a series of like items, which is traditionally the way this rule of construction is employed. But I think the majority is wrong because they essentially write a new contract for the parties. That's the problem that I have with it. And I think the opinion, the dissent is right on. The key point is that the parties, that it's brought out by the dissent, is that the parties identified specific remedies and listed them.
You just said remedies plural, but then your whole argument was that there was only one remedy.
Well,
and yet you want us to adopt the dissent.
I think that even if we say that the parties identified a specific remedy and one potential remedies, a pocket of potential remedies, they went to the effort of listing them. Nothing indicates that they had other remedies in mind. So the parties agreed to limit their available remedies. What the majority does, they just throw that out. They write a new contract. That's not permissible. And it's not permissible to render meaningless provisions in a contract. The court is not permitted to do that. But I believe that the dissent And Judge McMillan in the circuit court analyzed this correctly. Even if there had been a breach of the agreement, they had their remedy. They complained, they withdrew, they took advantage of the remedy listed.
Counsel, you've raised what I view as a subtly different argument in the last few moments. I'd like to ask you if you can develop it just a little bit. And that subtly different argument is that, but for the idea that the remedy laid out here is the exclusive remedy, there would be no point in including this language in the contract.
Yes.
Will you develop that with some precision, if you would, please?
Well, they went to the trouble of identifying a specific remedy. What do we do in the event of default?
It's a fairly pedestrian remedy, too, is it not fair to say?
Pedestrian in the sense of what, walking away?
No, fairly pedestrian in the sense that arguably it would be considered as a remedy whether or not there was such a provision of this sort.
You mean if it was not mentioned at all, it would be a remedy?
Arguably.
Arguably. You have to consider also the fact that nowhere did they indicate that they had in mind other remedies. This is the only remedies that they specify.
Maybe Justice Markman could develop this with opposing counsel, this theory.
So am I over? I'm over.
You're out of time. So,
I'm sorry.
But if Justice Markman has additional questions, I want him to.
That's fine, thank you.
Very good. Thank you.
There may be some questions for opposing counsel on this.
Good morning, Your Honors. Kelly Cruzy on behalf of the plaintiff appellees. The question before the court is whether the expressio unius doctrine applies or whether paragraph 10 of the contract should be enforced to bar my clients from pursuing the breach of contract complaint. And I would suggest to you that if you look at the record in the trial court, one of the things you'll find is that there's no record from which the court can discern the intent of the parties with respect to paragraph 10. And the reason for that is it was never raised as a defense. It was not an affirmative defense. It was not raised in the answer. In fact, it wasn't raised until the reply to the defendant's motion for summary disposition. So there's really no record from which to discern the intent. We can look at the contract, but if we look at the contract, I think it steers us in favor of the plaintiff being able to pursue their claims. Because if we look at the contract, we have to look at other doctrines concerning contract interpretation and other procedural rules. First of all, the procedural rule is that this argument arose on a motion for summary disposition, a C-10 motion for summary disposition. And so we have to construe all the facts, everything in the light most favorable to the plaintiffs. Secondly, we have to review the contract as a whole. And Your Honor raised, I think, what is a key point, and that is that paragraph 11 says we incorporate all of the provisions of the lease into the contract. Paragraph 47 of the lease specifically says that it applies both before and after the lease is signed and takes effect. And it says that any and all remedies available under law are available to the parties. So if we read that in conjunction with paragraph 10, which says that any other remedies to which the parties may agree, and we refer to paragraph 47 of the lease, where the parties have agreed to any and all remedies available under law, the Court of Appeals correctly determined that the trial court erred and my clients should be allowed to proceed. We also have to acknowledge and respect that Mr. Underwood drafted this contract, and he was an attorney, and he drafted it specifically for this particular circumstance. This was not a form that he used. So he had the choice of which words he should include. And he chose not to include language that would specify that it was only, these were the only or the exclusive remedies.
Okay, let me go through your list. You started with this is a C-10 motion. I don't understand why that makes a difference. It's still a motion to resolve this thing summarily, and it's on a contract. So do we not start by looking at the terms and language of the contract? You tell us to look at the contract as a whole, and you refer to paragraph 11 as saying that it accepts and incorporates the lease before and after it's signed. That's a very broad statement. What it actually says is preliminary to the signing of the lease and after. So preliminary to suggests to me it's closer in time to when there's actually going to be a signing. And in as much as nothing happened here to get you close to moving in, I don't think that's preliminary to. But even if we incorporate it, your argument seems to be focused on paragraph 47 and ignores paragraph 3 of the lease, which required for the lease to be actually effective and signed and operating. So I guess I'm a little bit concerned that the interpretation of the majority in the Court of Appeals effectively rendered paragraph 10 a nullity.
Well, I don't think it did, because for the reasons that you point out, then it seems to me we have an ambiguous contract here. And if we have an ambiguous contract, we're going to have to look to the intent of the parties. We're going to have to look to what they anticipated and what they expected and what they thought this meant. That was not at all.
Help me get me to the ambiguity.
Well, if paragraph 3 says that it takes effect and becomes binding upon the party's execution, and paragraph 47 seems to indicate that the terms of it are binding before execution. And then we have paragraph...
Well, I read paragraph 7 is referencing all the terms of the lease agreement which allows the parties to use any remedies available by law. So paragraph 47 would override paragraph 10, but only if the lease is executed per paragraph 3. So I'm having a hard time finding an ambiguity. And even if we go to paragraph 11 of the letter agreement, now, to me, preliminary to the signing of the lease suggests that we are imminent and ready to sign the lease. And when we look at the facts here, it wasn't even close to a lease being executed. This was a real problem here. There was no movement towards getting an occupancy. And therefore, it takes me right back to paragraph 10. What's the remedy? You want to ignore paragraph 10, and I'm troubled by that.
No, I don't want to ignore paragraph 10, but I think that because paragraph 11 says that the lease is going to be govern the rights and duties of the parties preliminary to and after its signing. And so I guess then we're looking at the word preliminary. And I think because we have to, one, construe this most strictly against the drafter, and two, because we do have to take it in the light most favorable to the plaintiff because it was summary judgment, preliminary has to be given an expansive reading. We don't know how long it could have taken. Mr. Underwood, my recollection is, was thinking, he kept telling them, it's going to be soon, it's going to be next week, it's going to be next month, it's going to be the next holiday weekend. So maybe that was preliminary too. But I don't think we can decide that as a matter of law.
Okay.
And I think that to focus further on your attention to paragraphs 10, we also have to look at the words that Mr. Underwood chose. He chose a permissive verb. And as I indicated in my brief, the case law is when you use a permissive word as opposed to a mandatory word, a shall or a must, then that is illustrating an intent to present options, not limits. And that's what I think Mr. Underwood was doing here. He's presenting options, and he puts those options right before the paragraph that says, and by the way, look at the lease also. So he's giving everybody options. What he certainly isn't doing is putting together a grouping or series of items, because other remedy that may be agreed to by the parties, that's not a remedy. That's an option, an explanation, a illustration of what the parties may do. He has one remedy, declare a default and walk away. It doesn't make a lot of sense that people would enter into a contract where their whole business is at stake and they'd have no remedy for damage if the other party didn't.
How would you
perform.
phrase it in the mandatory?
He could have said very easily, the only remedies available to the party are this. These are the exclusive remedies for a breach. I mean, he was an attorney.
I understand, but it says the failure of either party to perform the preliminary duties outlined in this agreement will permit the obligee of the duty either to declare the void or the other agreeable remedy.
But he doesn't say either.
Okay, or another remedy that must be agreed to by the parties.
Doesn't say
That
another
may be
either, does it?
agreed
Or
to.
other.
Maybe. I mean, there's a lot of permissive words in here, and I think we have to recognize that he could have used mandatory words and he chose not to.
But it's a letter agreement on what we're going to do. And so to put mandatory language in suggests that if there's a delay, you must declare a breach.
No, not that you must declare a breach, but that your only remedy is to declare a breach. I think there's a difference there. He could have said that the failure of either party to perform the preliminary duties outlined in this.
What's the purpose of paragraph 10 then if it's purely that this is something you may do?
It's illustrative. It's illustrative of what your remedies may be. I mean, I don't know what his thought process was, because again, this was never raised, so we didn't pursue this or discuss it during discovery. But it could have very well been that I need to have a remedy paragraph.
But before we get to what the parties are thinking, don't we just look at the words?
We can, but the words are ambiguous.
Well, okay.
They don't, I mean, I think the ambiguity is clear from Your Honor's questions from the Court of Appeals versus the trial court's interpretation, from trying to compare paragraphs 10 and 11 to paragraph 47 in the lease. These all raise a lot of ambiguities, and Mr. Underwood's failure to use clear language has created that ambiguity, and he should not benefit from it.
If there'd been no paragraph 10 in this agreement, would the remedy outlined in paragraph 10 been available to the parties? Rescission, essentially?
If there'd been no paragraph 10, if there was no remedy provision, sure, they could certainly say.
Okay, well, you say sure, so my response to you is, sure, then what does this add to things but to suggest that it might indeed be an exclusive remedy?
I think it's intended to provide, to have a remedy provision in there. I really don't know what Mr. Underwood was thinking.
But I know what you said. You said sure. You said that this remedy would be implicit in the contract, even absent paragraph 10. Fine. They put paragraph 10 in there. Does that not suggest that something more is intended? And the only thing more that I can easily think of is the exclusiveness of this remedy.
Well, if that's what he intended to include, then he could have written that.
We know
He
it could have
didn't.
done better. You know, we don't get many contract appeals in this court in which there are perfect contracts. This is not such a contract, but my question remains, why isn't it implicit that something more was intended to be communicated here by your acceptance of the proposition, of the premise that this remedy would have been available even absent paragraph 10?
Because he also included paragraph 11. He included a paragraph that says, and also look to the lease. And in the lease, we have other remedies. And he says that lease is going to be incorporated preliminary to and after its signing. So,
But interestingly, the word preliminary is used in both 10 and 11. So it incorporates 11, preliminary to the signing of the lease, but paragraph 10 refers to the failure to do the preliminary duties. So if there's a failure to do the preliminary duties, you never get to the incorporation preliminary to the signing of the lease.
it depends how broadly we're going to define preliminary. The duties, preliminary duties, are all of the duties contained in paragraphs 1 through 11. So that's a broad range over an extended period of time. And so if we're going to have an extended period of time for the obligations in paragraphs 1 through, I guess, 9, or 1, then we can have an extended period of time for preliminary as it refers to the signing of the lease. You know,
So if paragraph 10 referred to everything from the time the letter agreement was signed, then there'd be no real purpose to the preliminary 2 language. It would be, let's just sign the lease at the same time.
I think you wouldn't do that because the time period for the lease, it was a 3-year lease, I believe. So if you sign the lease at the same time as the contract, does the lease start to run before you even have possession?
Okay, so now we're giving meaning to the word preliminary 2 that's different from what you just described.
No, the reason, if he's using preliminary to mean the entire time period, in paragraph 10, to mean the entire time period that he's getting the premises ready for occupation or possession, that can be a pretty long period of time. So if preliminary means a significant period of time in paragraph 10, don't we have to give it the same definition in paragraph 11, that it's a significant paragraph of time? He didn't have to say the lease terms are incorporated preliminary to the signing of the lease. He chose to do that. We have to give that word and that paragraph effect as well.
Is not the entire cause of action of the plaintiff that the defendant did nothing?
Well, that he didn't do enough. He didn't do enough to get them a certificate of occupancy. He claimed he did a whole bunch of stuff. He claimed that he put in elevators and he drywalled and destroyed and reconstructed. He claimed he did a lot, but not enough to get them a certificate of occupancy.
Thank you.
Thank you, counsel.
Thank you, Your Honors.
The case will be submitted.